Good morning, sir. Are you Pharrell Gilbert?
Yes, ma'am.
And Mr. Kenneth, will your client waive the formal reading of the indictment?
He does.
Mr. Gilbert.
All right. Right out of the gate, this is a third DWI. That's not a slap on the wrist situation anymore. In Texas, a third driving while intoxicated charge jumps to a felony. That means prison time is very real. And notice how smoothly this is moving? Waiving the formal reading, confirming prior convictions, that usually signals a plea deal is already locked in. This isn't a fight, it's damage control. Quick question for you. After 2 prior DWI convictions, should the system get stricter, or is probation still the right call? Let's see what the deal low. Let's hear the ruling.
Attorney.
Yes, ma'am, I did.
Do you fully understand that?
Yes, ma'am.
And do you understand, if I follow the agreement that you've made with the district attorney, that you will be waiving or giving up any right to appeal?
Yes, ma'am.
Now, it looks like the agreement that you've reached is for a 10-year term in prison, but that would be probated for 5 years. You would be ordered to pay a $1,500 fine and follow all of the rules and conditions of probation, including that 10-day upfront time. Now, with regard to weekends, I'll make that decision when we come back for sentencing.
Yes, ma'am.
So I'll need to see, what your work schedule is and things like that. So I'm not going to allow that to be necessarily part of the agreement. That's just going to be up to me at sentencing. Do you understand?
Yes, ma'am.
All right. So I'm going to mark through that with everyone's permission. Mr. Smith, Mr. Crawford.
Yes.
Do you also understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law?
Yes, ma'am.
State tenders number 1.
No objection.
It's admitted. Is there any evidence that Mr. Gilbert is not competent?
There's not.
All right, sir, I'm going to find that you entered your plea of guilty and true freely and voluntarily. Find that you're mentally competent and understand the nature and the consequences of that plea. Find sufficient evidence to find you guilty. However, I'm going to reset your case so that the probation department can do a pre-sentence report, and then we'll come back later for sentencing. When you leave here today, you need to stop and talk to probation. She's sitting at that desk right behind you, okay?
All right.
All right, we'll see you back at sentencing. Thank you.
Thank you, Judge. I just leave with that.
It looks like previously
It may have been,
to reduce the charge or to...
no, that's what they were requesting that I do.
And now, the tone shifts completely. We just went from a negotiated felony DWI to a first-degree murder case. That's a massive escalation. Here's what's happening. The state offered a 30-year cap. That means if she pleads guilty, the judge could give up to 30 years, but not more. If she rejects it, she's risking anywhere from 5 years to life. That is a high-stakes gamble. Legally, once this plea is rejected on the record, it may not come back. Prosecutors aren't required to reoffer it. This is the no turning back moment. So what would you do? Take a guaranteed cap at 30 or roll the dice with a jury?
Here today with Mr. Gertz that shows that the district attorney's office has made an offer, if you wanted to enter a plea of guilty, for a cap of 30 years in prison, which means you would be leaving your punishment up to me. I could give you 30 years. I could give you less. It would depend on any information that was brought to me at a sentencing hearing. You have every right to reject that and have your case set for trial. I just want to make sure you understand possible consequences if we go to trial and what your options are. And do you understand all of that?
Yes, Sean.
And do you want to reject that offer and have your case set for trial?
Yes, Sean.
All right. And so based on kind of some of this back and forth, is there any reason to believe anything would change with regard to that offer?
No, you're not.
So I want to make everyone, make sure everybody's clear that there will not be a plea. This plea agreement will.
Now, we're in even deeper water. Capital murder of multiple persons. And this hearing isn't about guilt. It's about bond. That's important. Bail hearings focus on 3 things: flight risk, danger to the community, and ability to pay. Not whether he did it, but whether he should be free while waiting for trial. 7 years already incarcerated. A prior conviction overturned. A $1 million bond before. and now the defense is asking for $250,000. That's not just a number, that's a statement. Here's the tension. How do you balance presumption of innocence with the reality of 4 homicide victims? This is where judges earn their paycheck.
With capital murder of multiple persons, Mr. Radford has filed a writ asking for a bail reduction. I think we talked about this and reset it so that the state could bring any witnesses, and then I would make my decision. Mr. Radford, do you have any witnesses?
Yes, we call Lively Stratton for the purposes of this hearing only.
Best you can, sir. Please raise your right hand. Do you swear or affirm the testimony in this hearing will be the truth, the whole truth, and nothing but the truth?
Yes, ma'am.
Thank you. Go ahead, Mr. Radford.
Can you state your name for the record?
Lively Stratton.
And Mr. Stratton, you are the defendant in this case, is that correct?
Yes, sir.
And what is your bond currently set at?
I think, after the appeal, I don't think my bond was ever set.
So it's your understanding that you have no bond at this time?
Yes, sir.
What was your bond set at prior to your trial?
I think it was $1 million bond.
Okay. And prior to this incident, have you ever been convicted? Well, you hadn't been, this conviction was overturned by the Court of Criminal Appeals, correct?
Yes, sir.
And prior to this incident, were you ever convicted of any crimes?
No, sir.
Where did you live at this time?
In Beaumont.
In Beaumont, did you have a job?
Yes, sir.
Okay, how long have you been incarcerated?
Going on 7 years.
7 years? Do you have any substantial savings or any monies that you have collected?
No, as far as my bond, everything would be, no contributions from like friends and family.
And if the judge were to set a $250,000 bond, do you think it's possible that you had family members and friends that could make that amount?
It'd be a stretch, but I think it'd be possible.
Pass away.
Any questions?
Mr. Patton, tell me about the means that your family has. What do your parents do? What kind of assets do they have? What kind of income do they have?
Well, my mom, she gets Social Security disability. My uncle, he's been a professor for the last 30 years. So I'm pretty sure he's got a good amount like saved up in travels and stuff like that.
Do your parents own their homes?
No, ma'am.
Do they have cars? Does your uncle own his home?
He probably does as well.
And he's a professor at Lamar?
No, he lives in another state.
So would you agree with me that amongst the members of your family,
So even though he's found guilty, he's not being sentenced yet, this pre-sentence report is like a deep background check. Criminal history, work life behavior. Judges rely heavily on this to decide whether someone gets mercy or maximum punishment.
you have considerable means to try to post a bond?
I wouldn't even say considerable because I mean, my uncle is really like tight as far as his money wise. So it'd just be even if he feels like doing it for me.
I don't have anything for you, Judge.
All right, thank you. Any other witnesses?
That's all I have, Judge.
Ms. Malfino?
Judge, I would call Detective Coffin.
Good morning, sir. Would you please raise your right hand? Do you swear or affirm the testimony you're going to give in this hearing will be the truth, the whole truth, and nothing but the truth? Thank you. Go ahead.
And before beginning, Judge, I ask the court to take judicial notice of the trial that you presided over some years ago, which gave you obviously a very good insight into the totality of the circumstances and the facts involving this case, and that there were 4 victims of this case. So just ask Detective Coffin, would you state your name for the record?
My name's Frank Coffin.
And were you one of the lead detectives on the case State versus Lively Stratton?
Yes, ma'am, I was.
And that involves the homicide of 4 individuals here next to Lamar campus here in Beaumont, Jefferson County.
Yes, ma'am.
And you were involved heavily in the trial process, preparation, et cetera, and you know what came before the court. Is there anything that you would like to add for Judge West's consideration with respect to a bond being set for Lively Stratton?
Well, Judge, I don't know that I nor Beaumont has seen a murder like this before, where 4 people were gunned down so close to a college campus, so carelessly, so quickly. And I can't recall anything like that before. So I think that in itself states that's a significant event as far as murder is concerned.
Detective Coffin, based on all of your years of training, experience, investigation of homicides, etc., do you feel like Lively Stratton presents a significant threat to the community of Beaumont if he is released?
Significant threat.
And do you feel like they're, based on the totality of all these circumstances, there's a great likelihood of his flight if he is released from custody?
I would imagine that there would be, if knowing what he's faced with, knowing the amount of time that he'd already been sentenced.
This is a massive gamble. Turning down a 30-year cap in a murder case means betting everything on a jury best case acquittal or a lighter sentence worst case life in prison. Would you risk either? Take the deal.
Prison time that he can be sentenced again, there's no upside to not leaving.
I don't have anything further, Judge, unless the court does. From the detective, I just have a couple of statements for argument.
Okay, no, thank you. Thank you, sir.
And Judge,
Oh, you
yeah.
have to ask questions. I'm sorry.
Detective Coffin, you testified at the trial, is that correct?
No, I
You
didn't.
did not? Did you observe the trial?
I did.
Okay.
Well, no, I did not. I'm
So you
sorry.
didn't watch the trial and you didn't testify at the trial?
No.
Okay, so you don't know what happened at the trial?
I was not there for the day-to-day, but I do know what happened. I was here at the courthouse helping prepare with evidence, with witnesses,
But you didn't watch the testimony, did you?
with interviews. I did not watch the individual testimony.
Were you aware that the jury found that two of the victims, evidently that they didn't convict him of killing the two guys with the knives? They convicted the two guys without weapons. Were you aware of that?
I'm not aware of the details of how many people or of how he killed each person. No.
Okay. That's all I have.
Anything else?
No, Judge.
All right. Thank you, sir.
Thank you, ma'am.
Ms. Malvino?
Judge, I would ask for a bond in this case that is equal with what the facts of this case are, with the fact that we have 4 homicide victims. I think an ask of $250,000 is extremely low. I think it's offensive to the court to ask for a number like that for all 4 individuals, maybe $250,000 per individual. So that's back at the $1 million bond that he was.
Okay. Decision time. After hearing testimony about 4 victims near a college campus, potential flight risk, and the defendant's financial reality, the court has to draw a line. A $1 million bond sounds enormous. But here's the nuance. Bond isn't supposed to be punishment. It's supposed to ensure appearance in court and protect the community. Add GPS monitoring and house arrest, and it's conditional freedom at best. This ruling tells us something. The judge believes bond is legally required here, but it's going to come with serious strings attached. Big question for you. In a multi-victim homicide case, should bond even be on the table? Or does public safety outweigh the presumption of release? Let's hear it.
The nature of this offense and in line with what I know about the case and the argument. What if there was bond made, there would be a GPS monitoring device required and house arrest. I would obviously, if that bond was made, need to know what that address would be. And then we will get the case set for an announcement and then move it to the trial as quickly as any you guys are ready to do that.
Do we have a discovery?
And Judge, I do have an update while we're here on it.
Sure.
With respect to discovery, Ms. Mayfield was very diligent in going through what we had, what we were able to locate on some thumb drives that we had made as just a backup in this case. Obviously, with the age of the case, et cetera, the court is aware of some of our hurdles we've had in recreating this massive file. Basically, we've also been working with Detective Coffin and BPD to make sure that we can get everything that is available to us to provide to Mr. Radford. I have done a spreadsheet type itemization of the media that I believe is there. What I would ask so that counsel and I are on the same page and to make sure we both have the same things is that he would go through and itemize this in comparison with mine and make sure to let me know if he feels like there's anything that's missing. I will do the same now with this media itemization. I will go through and compare it to the hard copy file itself and cross over and make sure that we're not missing anything. But I do have 2 flash drives to turn over to him today. I also have spoken with multiple family members, and when the court has a little bit of a slower period towards that first part of March, we have meetings set up to meet with the family. I feel like I'm in constant contact.
Okay. All right. So yeah, if you guys will go through that, if there's any issues that you need me to get involved with for any reason, just let me know. Do you anticipate the time to go through some of that to get closer to where we need to be longer? You want to do a little longer?
Yes,
recent?
ma'am. I've got 2 big trials coming up in Orange, one at the end of this month and one at the end of February.
What I'll do is 60 days and let's just see where we get, start going through that media.
We do the end of March, so I'm gonna be going in April.
Whatever 60 days
I'll
is,
get
or
it covered.
make sure you have a vacation letter
I will.
on file, and we'll work around that
Thank you.
and start going through it in the meantime, so that when we get here, you've at least gone through and we know it better where we are on the media and the discovery and things like that.
Yes, ma'am.
Okay.
Thank you, Judge.
All right, you can go back with the bailiff. Thank you, Detective. And I don't have an order. If you can
Okay.
send an order over, please. This is just for me to remember. I don't know if it's all when in April, we'll just have to say,